Hi, my name is Hannah. I'm going to be jumping into part 2 of this video. By now, you should have received the facts of the Palsgraf versus the rail company case, and you should have also received the issue of this case as well. So now we are going to be jumping into the decision, the reasoning behind the decision, and some key takeaways at the end. So stay tuned. So first off, I wanted to discuss just a brief overview. We talked about how Palsgraf has received injuries from an explosion that happened from the passengers on a train holding a package. So she sued because she received injuries and she thought that the company was being negligent or held liable for her injuries. So that is the issue. Are they considered negligent? Or are they liable? Short answer, no, they're not. The court actually concluded that there was no negligence because the defendant could have not foreseen its employees' conduct or behavior in this case, intending any injury on anyone or even Helen. So actually too, in this case, the appellate division also affirmed this decision, but the Court of Appeals in New York ended up reversing it. That was actually kind of interesting to read on. But the reasoning behind this decision was the conduct of the railroad guards was to the holder of the package. So they were kind of more interested in helping the passengers on the train than causing injury to anyone or intending anything wrongful. Nothing in the situation gave notice that the falling package or the contents in the package when it fell would have caused any injury. So they had no idea, except the passengers, of course, holding the package. Negligence in this case is not actionable unless it actually involves the invasion of a legally protected interest or the violation of a right of an individual. So proof of negligence, so to speak, in this case, will not do, because even the plaintiff must have shown that some wrong was done to herself or a violation of her rights were, so to speak, there was a violation, but there really wasn't. In this case, there was nothing to really indicate that the contents in the package, when it dropped, would have caused an explosion. So in this case, it was really interesting to do research and read on, because this case is definitely one to be in tort law. It also helped with the establishment of the idea of proximate cause, because it, set the limit on the scope of tort liability. But as we know too, proximate cause only means that you can only hold a defendant liable for harm that is only a reasonably foreseeable result of the wrongful act, which in this case there was no intentions, or the company had no idea of what could have happened, but it did end up happening anyways. This case was definitely a popular one to be studied on amongst many law students, I have heard, which is really interesting. And I'm very grateful to have the opportunity to be able to study this. And I also send a huge thank you to my partner in this group as well, who has done part 1 of this case as well. So I really hope you enjoy this presentation as much as I do. Thank you.